KZSU-FM Stanford. Welcome to another edition of Hearsay Culture on the Hearsay Culture Network. My name is Dave Levine. I'm a professor at Elon University School of Law, as well as an affiliate scholar at the Center for Internet and Society at Stanford Law School. I'm also now affiliated with UNC Law's Center for Information Technology Policy, as well as the University of Milan's Information Law Center. We are fortunate to have on today someone who has seen into the future of sorts with regard to AI. The author of 2019's On Legal AI, Jay Walker. On Legal AI is a book that I was aware of when it came out because I have known Jay going back almost 20 years now when we met, when we were both working at Stanford, me as a fellow at the Center for Internet and Society, and Jay at across campus at Codex, the truly brilliant operation at a CS department that was one of the early actors in thinking about technology policy and has put out some great work, has also been the launching pad for some terrific academics like Hearsay. And from there, Jay and I have been in touch over the years, but not as much until recently, and more recently when a few years ago, I came across Jay's book. Published in 2019, what Jay has done in On Legal AI is to look not at, per se, the law around artificial intelligence, but more specifically on what lawyers can do with artificial intelligence, how lawyers can incorporate technology into practice, and then based upon Jay's background in computer science and computer technology, how to think in a sense like a systems engineer and how to think like a problem solver. Very, very important skills to have aside from generative AI, but generally as an attorney. Lawyers are trained to solve problems. They are paid to solve problems. And the history of legal practice, which we're not going to get into here, goes back to the books, reading laws, applying facts to laws, coming up with conclusions, drafting documents, and so forth. We know already, or we have a sense of what generative AI is doing to any of the creative professions, including law. But what Jay wrote a couple of years ago is really very useful, very different, and I would say very unique, which is to take the bull by the horns and say this technology exists, although again, to be clear, the book was published prior to the launch of ChatGPT and really the world's increasing understanding of it, to say what can be done as lawyers that allows this way of technological thinking to improve your efficiency and to improve your legal practice. But more broadly, it really is very much about lawyering, right? And that's what we're going to be talking about today over the next 50 or so minutes with Jay. Jay, who is joining us via Zoom, is the CEO of System Legal. As I mentioned, he was also involved in the early days of Codex, which he talks about a little bit in the book, as well as being one of the founders of Lex Machina, which was and is one of the entities that look to bring data processing and data analytics into, in that case, the understanding of patent law. We're going to have a wide-ranging discussion today. Jay, I am so excited, my friend, to have you on Hearsay Culture after all these years with such a timely and important topic right now.
Dave, thank you so much for that great introduction and well spoken, man. We go back way back to the old country, which happens to be Silicon Valley in this case.
Yes. Yes.
And the more things change, the more they stay the same in a lot of ways. But thrilled to be back here. Thanks so much for the invite.
Of course. Let's jump right in, because anyone listening to Hearsay Culture, and probably anyone that's thinking about these issues, will say, oh, On Legal AI must be about the law of AI. And I want you to amplify a little bit more what I was saying. The book, to me, is really about lawyers as problem solvers and lawyers as engineers. Take it from there.
And so it's legal AI two ways. So that's really well framed. And there are a few different meanings floating around. So we do refer to AI that is legal, but primarily it's using AI in the practice of law to make the practice better. Judicial understanding, all of that stuff. it's legal AI two ways, like a fancy restaurant or something like that. In the first sense, it's a cookbook on how to make legal AI competently, which is not as easy as it sounds. And there's a lot of hubris, both from the legal side and the engineering side, in doing this. And the second is how to make AI legal at scale. And the punchline there is we use legal AI to make AI legal. You really can't. The scale of activity and fraud and the good stuff in AI is so vast, and it's moving at such a fast pace that you actually have to use AI to help manage it and govern it. And that's the point. But the main stories that are in here about how we created Lex Machina and how we created some things at this the Stanford Center. Very briefly, there was a database, so that we had a center. We didn't have a lot of big projects yet back in the day. And there's a professor named Mark Lenley that we both know, a brilliant guy. He raised millions and millions of dollars.
Multiple Hearsay guest, by the way.
I think wonderful.
Mark's been on the show more than anyone else. Yeah, go ahead.
I'm in good company. So he raised a ton of money. He had an idea for an IP litigation clearinghouse. And what that was is, at the time, we had no idea, really, very limited idea, how many patent cases, lawsuits there were in the US, or particularly what happened to them. We had no data on trade secret lawsuits, very limited data on copyright and trademark lawsuits in the federal system, not to mention the state systems. And that's a huge problem. It's like you're running a factory. I mean, yes, it's justice, and this is a crude metaphor, but it's like you're running a factory and you have no idea how many shoes, raw materials are going in, how many shoes are going out, or what the error rate is, like how many bad shoes are getting cranked out of the system. And maybe there's different, some are boots and some are shoes, and you don't really know. It's a crazy way to do that. That problem, the risk with that kind of project was, at the time, in about 2006 was when we were there. In 2006, there was no real reason that project was going to succeed. There had been a similar project that was done with securities class actions, but they're only about, at the time, 230 class actions a year. We had to analyze over 120,000 cases. And I was fortunate to be the first employee at this, and I didn't want to do it initially because A, it sounded boring, and B, it was doomed to fail, because you can't analyze 120,000 cases, any one of which can be incredibly complicated, 9,000 different events, antitrust issues, all this stuff, just for patent within that system. So well, it was just me at the time. So I walked across campus, and as a really junior person, you were there as well, with a really cool mandate and set of activities at the Center for Internet Society. Walked across campus and tried to convince this famous computer scientist named Chris Manning to help us. And Chris was maybe one of the top natural language processing and computer scientists in the world at the time. He said, "Go away." And I went back again. He said, "Go away again." And I said, No. Natural language, what lawyers do, is uniquely structured in a way that makes it much more usable and amenable to text analysis than other stuff in Wall Street Journal or stuff on the internet.
Can I pause you on that, Jay? Because
sure.
That, I think, is an essential point right up front. Can you explain for our listeners why law is so conducive then and now to this kind of computer systems analysis that you write about in the book?
Absolutely. I'm going to answer it in two parts.
Good.
One, at a high level, law and computer science, to me, and this is what I said to Chris before he threw me out of his office again. And Chris is amazing, by the way. There's a happy ending, but initially it was like, go away. This guy said no to everybody at the time, and no reason he wanted to talk to us. Law deals with classification and procedures. Classification, what is the tax treatment of this asset or this thing, or who does it belong to? Does it belong to Betty, or does it belong to Sue or Bob? So it's classification is a big thing. Law also deals with procedures. So law deals with classification and procedures. Computer science does the same thing. So classification, two minor examples, and we can delve into it, but two minor examples are classifiers. So you actually classify two bits of data it's a fundamental thing that any machine learning tool does is deciding between one and the other. Is it an apple? Is it a cat or an orangutan or a donut or a wheel? Like those are classification problems that are very classic. Any data clustering is a kind of a classification problem, and certainly doing prediction of what the text should be in generative AI is a kind of classification problem initially. The second thing that computer science does is also procedures, the algorithms. An algorithm is defined as a set of finite steps that do not involve intelligence, but that lead you to an output. And so to me, that's like the judicial system. Again, it's a very crude metaphor. I'm not an engineer. I'm not a computer scientist. I know just enough to try to bring some advantage to law. I'm just a liberal arts nerd. But knowing a little bit can actually take us a long way because there's such synchrony between these two things. Not true of business, by the way. Business, like the MBAs we worked with, were very different. Like they just have different foci and things. But law and computer science are naturally aligned. The second part of your question is the text. Legal text, what lawyers are writing, is much more structured than regular language. And therefore, that structure can be revealed and possibly generated. I think we knew all that then, and maybe it's just me at the time, but that was something that was I was really trying to put out there. The thing that we didn't know, that nobody knew at the time, I think, was how much text is actually core to understanding, period, including something called a world model. And a world model.
Let me pause you there again, Jay, because this is such important stuff. I want to make sure, though, because this can get dense quickly, to sum it up in a manner of speaking, and tell me if I'm wrong, right? What we're thinking about here is the notion that computers and computer systems operate in a system of logic, right, and structure that can be mapped in some useful ways onto the kinds of systems and logic that lawyers use to analyze facts or make arguments and therefore solve problems. Is that an oversimplification, or is that a fair assessment of the insight that exists here?
The spirit of that is exactly right. I'm going to qualify it a little bit, though. And the reason I'm going to do that is the word logic is a very specific term of art in computer science. And there has been, well, shall we say, a schism between the logic AI people and the statistical AI people. It's existed since at least the 1960s, when AI as such got started.
All right, tell us about that. Yeah.
Some of the first AI systems were called expert systems, and they were programmed. Someone sat down and said, I'm going to figure out how to do all these things. And if someone says X, it's going to say Y or Z, and follow down a very explicit logical tree and or statements, right? So it's like Aristotle stuff. I mean, it essentially is doing classic logic maneuvers. Now, logic is part of every computer system. Every bit involves and or gates. But logic as a means of creating AI, including Siri, by the way. Siri is based on a knowledge representation philosophy to some extent, which is closer to logic. Then, so some people want, I want to sit down, I'm going to define all the logical parts of this tree to say, do you have a cold or is it the flu, for instance? There are other people, the other approach to this is saying, I'm ignoring all of that. I'm going to take data. And this didn't always work. It started to work for real in a self-supervised way in 2018. I'm going to look at all the data and I'm going to map statistical correlations to it automatically and use very, very complicated, essentially operationalized mathematical tools called transformers, and use essentially differential calculus. Not to nerd out too much, but
yeah, let's not.
We're in good.
Differential calculus, we just lost half of the listeners. So let's.
I know.
We will not be covering calculus on the Hearsay.
We will not be covering calculus, but essentially it's math.
Yeah.
So if you just do mathematical operations on a big set of really good data, it's going to spit out the answer. Mm-hmm. And so it's a highly automated. It's not a created by a human. It's not even supervised necessarily. This construct automatically at great scale maps connections between things, mm-hmm. and clusters the data, for instance. And that's what ChatGPT is doing. It's essentially a letter predictor,
right?
But using the innovation of money, large numbers of servers, and some really cutting edge approaches, including I won't go into it, but using some really cutting edge mathematical approaches, it's able to better predict letters that people want. It's able to maybe not understand something, but have a model of, oh, this is a bird, and a bird is different than a bagel. Mm-hmm. And bagels are a breakfast food, and not all birds are eaten at breakfast. Some of them are flying around. So it starts to, just because of the scale of text, arguably understand things. Not particularly well yet. It's not like a first-year associate at a law firm, for instance, but the scale of this compounds and gets better and better and better. So those are the two different ends of it.
Right.
In either case, the natural structure in the law makes it more amenable, not less, to artificial intelligence analysis.
And so we're talking with Jay Walker, author of the book on legal AI on KZSU-FM Stanford and Hearsay Culture on the Hearsay Culture Network. These letter predictors, as you've described them, right, are just that. They're prediction engines, and yet, right, to the naked eye, they seem like they get things. They seem like they understand things because of the outputs, which is another, right, interesting thing that we do as lawyers, right? We put information out there in ways that makes it clear to others, but also makes it appear that we know what we're talking about. So I want to dive in a little bit on that point, because, right, your book predates generative AI. I want to make, or at least predates generative AI that anyone had access to. Maybe Bill Gates was looking at early models of ChatGPT, but we weren't.
Totally.
Right. Are you surprised by the existence of ChatGPT, even though, most people were, but I'm curious, even though you also identify as you define it, the AI event horizon, right? The idea that we really can't predict, right, what's going to happen with AI with any, degree of confidence after a very short period of time in the future. Where is generative AI on the level of surprise for you, but also, conversely, on the level of, yeah, that's the next logical step?
The answer is both. Absolutely both. And I hope the book is more useful, not less, because it's really a cookbook for legal structure, not just and policy of how we use these things, not just the mathematics, if you will, that we touched on that. Everyone was surprised by the performance of ChatGPT, especially the people building it. I mean, some people, you were like, yeah, this is going to crank it, but they had lots of failures. I think they were working on physical robots, which are very hard to deal with, by the way. Unloading a dishwasher and deboning a chicken are two of the greatest AI challenges that they've not been solved, right? Uh-huh. That's like, so there's the chicken test and the Turing test, but no one really expected this to work as well as it did. I think we knew that there was really a resonance between law and AI. If you look at the bar exam, now bar exam hard to do, and I'm not nothing I'm saying is pejorative of AI or the bar exam, but the bar examiners, they want two things. One, they want a median answer. They don't want you saying anything weird. They want a median answer, which is exactly what this AI is designed to generate, the median answer. And we want also essentially, you have to memorize tons of stuff, which computers are going to do better than a human can't overpower a locomotive. Like the memory of 50,000 servers is going to exceed any humans by definition. It's like we can't fly faster than planes. We can jump. So it naturally resonates. The legal AI tools that are being created for enterprise, they hallucinate less, arguably. They hallucinate less.
And hallucinate meaning make stuff up.
They make up citations right. less than, say, ChatGPT,
right.
Which is not tuned to a very specific empirical data set.
I just want to be clear about what we mean by hallucinate. Right.
Yes.
Yeah.
So it's not on LSD. You don't want a lawyer on LSD, essentially. And if you just are using a ChatGPT for legal advice, first of all, I tell you it doesn't do that. But second, it's a little bit like asking your friend who just finished her first semester or year at law school for legal advice. You're both, you know what you're doing, and someone asks you for legal advice, and gosh darn it, you give that advice. Like which is terrible. So again, you're not attuned, you're not licensed. So there's formal problems of certification, and there's also like you have no idea what you're talking about, right? And so, but that hubris from lack of knowledge is significant. So the generative part is actually not as important as something else right now. What these things do, so the underlying, I'll try not to nerd out, but the underlying technology is called a transformer. It's a very specific way of doing a neural network, the AI, that came out of Google actually in about 2018, 2017 time period. And a transformer, what these kinds of transformers are extraordinarily good at is taking a vast amount of text and summarizing it. So if you don't have control over the data set, it can summarize things in a way that is just nonsense or made up. You can summarize someone else making up something, right? You can just take it from the web. If it's summarizing judicial orders, it's going to be very, very good at that relative to other past AI performance. So that is transformative. The way, what I haven't seen is generative AI constructing a perfect logical as well as, empirical, statistically accurate memo, for instance, that's going to outperform a first-year associate. Mm-hmm. It can summarize, and it's extraordinarily good at doing that, and it can predict what you'd want to write. And we'll get to the memo full auto generation. This is already happening. I just haven't seen it proven yet. And so we need to be skeptical until something is proven, because that's our job, is to prove stuff, not just to assume it.
The timing of this discussion as it is on January 23rd, since you raised it, Josh, Jay, I want to ask you. So I got an email this morning from a colleague that said, FYI, Lexis, which is one of the legal databases that lawyers and law students use, is making available, at least to our second-year law students, their case summary AI, which for non-lawyers and non-law students means that exactly what Jay has just referred to is being offered directly to law students via not ChatGPT, but via Lexis, which is not ChatGPT. For again, people that aren't in law school or haven't gone to law school, one of the core skills that we teach in law is how to, what we call, brief a case, which is exactly what Jay's referring to, how to summarize a case based upon what facts are important and what law's doing. And Jay, you have said that this is what these transformers and this is what ChatGPT does so well, which leads to, right, another question in the space of your book, which is, right, you talk a lot in the book about your experience with what firms want lawyers to be doing, right, what employers want lawyers to be doing, and what lawyers can actually do. You mention, and I want to quote them because I think they're really helpful. In the book, you talk about 4 axioms, right? 4 axioms that lawyers in particular need to think about, but I would suggest that we need to think about more broadly. And I want to quote them and then have you talk about them in the context of, right, what AI is doing and what AI can be doing. So here are those four axioms, and what you say, and I'm just going to read from the book, right? To control AI, to avoid future human misuse of AI, to avoid dangerous evolutionary branchings of or self-learning by AI, the law, and you lawyers, you write, I mean you specifically, must adopt AI in our control mechanisms because, and I'm just going to quote the axioms. 1, AI is fast. 2, AI is cheap. 3, you being lawyers are neither. And then later on, you say 4, horsepower is a remedy to special problems in horse law. Now, I want to put aside the fourth one because that's also a nerdy reference to the law of AI and computers. But I want to put that aside for a moment. AI is fast. AI is cheap. You are neither. Wouldn't a logical conclusion, and I'm thinking of my law students, wouldn't a logical conclusion be, wow, the game is up, right? Because now, fast forward to 2024, again, you're writing this in 2019, Lexus is already briefing cases, right? I am not fast. I'm not as fast as that. I'm far more expensive, right? And so things are not looking good for us creatives, us lawyers. What's your take on that critique of the day?
So the first thing is we don't know where this will go. So there is some uncertainty. I call this class 4 disjunction. And so if you've ever been to, I don't know, the Chattahoochee River or Chattanooga River,
Right.
There's some whitewater. Class 4 will kill you, but it's not class 5 or 6. So class 5 disruption is like there's no more human lawyers. And I don't see that yet. I do see very, very significant disruptions. And it's like there is a hype bubble. People will be disappointed when they start using it. And I've seen lots of GCs be disappointed with some of the state-of-the-art tools that have come out in the last year. But there is a major disruption that's happening. And it has to do with at least the information extraction. And you may want to teach people to IRAC anyway, because it's good discipline for us to know how to do that. And it forces us when I created a law school outline.
By IRAC, to be clear for the non-lawyers, you mean for our purposes, briefing cases. Yes.
Briefing cases, pardon me. Yes. Yeah. So that's really important to do. And it's the questions you're grappling with, I don't envy you. It's what anyone who deals with text of any kind or creativity of any kind, what are you going to teach people now? Using the tool that you mentioned, whether it's Lexis or their Lex Machina thing, which is another story, you have to learn how to use these tools. You have to leverage them, but taking a summary of a case and constructing an artful argument and a well-written, well-formed document that's going to achieve your client's benefit, hugely different things. And so you have to learn how to use these things, not just to trust in them, but to leverage them to make yourself better. So I think that's quite different. And that was not true even in 2018. For patent law, everybody had to use data. Like you couldn't really practice patent law. Now, all lawyers will have to use AI. I don't think you can be a practicing lawyer without some facility with this, or you're really good at working with people who are. You don't have to be technical, but you need some familiarity enough to learn to grapple with it and grok with it. Let me explain what I mean by legal engineering, because I think this is really important in this conversation.
That was going to be my next question. Go ahead.
So I'll give you the punchline and then the story behind it. When I say legal engineering, I mean, there are people who can still be writing briefs and doing one-offs. But when I was a lawyer as an associate in a law firm or even in-house, I'd be writing a memo or writing a single motion document. It's a huge amount of effort, hundreds of thousands of dollars potentially, or more, sometimes millions of dollars per brief. Like these are very expensive documents to create in terms of humans and time. But it was like an artisanal product. We filed it, we never used it again. Yes, it was in the firm library and you could reference it, but it was essentially never used again. When I say legal engineer, what I'm saying is also need, in addition to the writing and the craftsmanship and the artisanry, which is still very important, and I love doing it. I do it myself now. In addition to that, we also need to be like software. We also need like a software engineering component. Law firms work on a high marginal cost, low fixed cost basis. You hire a law firm, they charge you by the hour, they bill a lot of hours, and then you pay for that. A software company is the opposite. You don't pay money to Google at all. You just use it, and they leverage that to make money, tons of money. But essentially, it's really, really difficult to build Google, a search engine like that, but very cheap to operate it for each additional, search request. In fact, it's the opposite. The more search requests they have, the better their search engine gets, which means the machine puts out more money and more goodness for them. And in theory, social benefit too. We need lawyers and legal projects that are also like kind of making films. And we see a lot of that. We see a lot of legal entrepreneurship. So again, that legal engineering is not to displace the artisan role and the trusted advisor role at all. It's that we also need those roles. So yes, some jobs will disappear, some paralegal jobs will disappear. There will be a major disruption, and we don't know exactly where it goes. But there's also going to be enormous numbers of new opportunities. Like there is something called a legal engineer now, which was not true a while back when we were first in the basement at our law school in Silicon Valley. There are all kinds of new jobs now, and people investing tens, hundreds of millions of dollars in these legal startups. That's a radical change, which should benefit people. The second piece of math we need to bear in mind, I will call it an empirical reality, though I'm speaking a little off the cuff. When I was on an AI panel for the state of California about how to use this to help people, essentially 20% of people that need legal counsel actually get it in California. And so big state. I think the number of actual need met is more like 2% or less. Right. I think lawyers have met less than 2% of the actual need for legal services in the world. The only way we can actually meet that need is by using technology and platforms like Google. We can serve 2 billion people if we can find a legally appropriate and good way to do it. Law firms can charge licensing fees. I was a flying car lawyer, a general counsel at Airbus in Silicon Valley, and I had fixed fee agreements for fixed sets of services within certain parameters with big law firms. You can do the same with software. Law firms can have software or software subsidiaries that can actually scale up some of what they're doing. And
let me pause you there, Jay, just quickly to say that we're listening to KZSU-FM Stanford and Hearsay Culture on the Hearsay Culture Network. KZSU is a nonprofit, non-commercial radio station at Stanford University, much closer, incidentally, to the computer science building than to the law school, down there in the basement of one of the theaters on campus. It requires donations from listeners like you to continue its programming. Please consider making a donation by emailing donate@kzsu.stanford.edu. Let me pause you here for a moment, Jay, because we're hitting on it now, right? The sea change that has existed since you wrote on Legal AI, encouraging lawyers to accept the fact that they have to embrace AI, right, has now happened, right? And so now your book becomes less present in the sense that you're predicting the future because you did, right? And more now, okay, it's on us. How do we think about it? So let me ask you this question at a very brass tacks level. Lots of people who are speaking the way you just have, and I know that you have a more nuanced view on it, but speaking about the benefits, which seem undeniable, right? I mean, if the technology can relatively easily, fast and cheaply put together a legal document that you wouldn't be able to put together at all, right? And I dealt with pro se litigants regularly when I worked for the city of New York, right? That's a net benefit, right? At the same time, though, right? At the same time, I think a lot of people kind of gloss over something you've alluded to here, and I want to press on it, which is at the end of the day, people will lose jobs, human beings will lose jobs. And this is my question for you. Your book is a roadmap for training, but that training isn't happening, Now, that might be on my side of the glass here, as it were, right? Law schools have to do this work, but then law schools are still grappling with how do we deal with plagiarism, right? Which predates generative AI. Now we're dealing with what do we do with students that are going to submit work that ChatGPT has written and ChatGPT has no answers. So what do we do right now, right? With legal AI, given that the technology, whether we like it or not, right, is available to everyone, more or less, that has a computer. People and entities are creating their own individualized versions of the technology. We're going to talk about a somewhat dystopian, disturbing example shortly involving political campaigns. Right now, you have lawyers listening to this show, right, in Silicon Valley, right? Stuck on 101 if you're still, commuting, right? You've got law students that are listening. What do you tell, let's start here, the law student right now, right? January 23rd, or this will air on January 26th, actually, to 2024. How do you be legal AI and deal with legal AI right now?
There's a very simple recipe in the book. Your
Mhm.
question is deep, and we'll touch on it. The
Yep.
simple recipe is EDEN. It's an acronym. It stands for Empirical Design Evolution Net. Just that acronym is going to help people grapple with this better. Empirical means, does it actually work? There's a lot of innovation theater in law and everywhere else, right? Most companies that are really integrating this stuff into their operations for life and death decision making and big stuff, and consumers, they're not doing it, right? It's just there's this, like, they're playing with it. And playing is helpful. It's a learning thing, but it's not the same as having something that's empirically grounded. So when we built the machine that Mark needed, right, which is to analyze all and code all the outcomes of all these IP and antitrust cases in the US, we had to build algorithms that can scale to anything else, so any other, tort law, to any lawsuit, essentially, because the AI had to scale, so it actually scales into other areas. And then you can do it for state now. So that's an empirical project, and we assume all data are false until proven otherwise. We assume we were wrong, and we gave it away free to judges and nonprofits and all scholars and any government official anywhere full time. And they told us when we were wrong. So there's an empirical test process as part of that, and the data itself are empirically grounded. Not true of a lot of the hallucinations you've seen in ChatGPT, and it's not even true of things that summarize doctrine. It's a very different type of data set where these AI are super useful, but it's different than that kind of outcome in this kind of application. Design is the next. Begin with a user in mind. If you ask most people who've been in a lawsuit, how was your user experience today? They would say it's like the worst system they've ever encountered in their life. Like, it doesn't matter whether it's a patent lawsuit, a divorce, a contract dispute, not all, right? And I know some incredible judges and incredible processes, but most of them would feel like this is terrible. They didn't know what was going on. If they're pro per, it's murder. Like, it's actually killing people that they can't grapple with this stuff. It's killing people. We have a project in Brazil called Citizens AI that's looking at how you create AI that helps people navigate some of the bureaucracy in the systems and paper management. So that can happen. So begin with the user in mind. If it's a billion, it's a public company. If it's the United States Senate, if it's the White House, I've had all these clients. Like, you have to think, what do they need? What do they really need to get their job done better to help people? And if your end user is a citizen or denizen of a country, of a nation state, what does she need? And so we don't think about that in the law, but software engineers do. Again, crudely and broadly, but they do. And we should be thinking about that. How do we create interfaces that regular people can use at much greater scale? Evolution and net. Net just means that we're going to look at the pluses and minuses. So I know we're not going to delve into the AI Act in Europe and other AI statutory and other things, but if you are going to regulate AI, you have to think of two things specifically. It's a specific technology. You need to think about Well, am I going to address the harm that I'm worried about? Maybe to privacy, intellectual property, having a media industry may be important to, say, Canada or Australia or other places. That people like media and they don't want it all, ground down into ground beef for someone else's hamburger. So that stuff's important. You also need to measure the cost and the harms you're going to be causing by that legal monopoly, that imposition. How many radiology AIs are not going to get built in Europe because the cost of designing them and building them is now 10x higher for little startups? How many startup ecosystems is it going to wipe out? So I don't know the answer to these things, but we're not measuring those things at all. We're addressing a very specific political constituency or faction at one point in time. We're not netting anything, and that's terrible for AI and it's terrible for policy. Last thing, evolution. Your system is going to be constantly changing. Again, Google's search algorithm is just one simple but really good example. It is constantly evolving. It never, ever stops evolving. When it does, that's the end of it. So same with OpenAI, same with Anthropic, same with any other AI product. It's constantly evolving. So our models and our tools we create have to get better, both in terms of procedures as well as that. The same thing that's true of building legal AI is true of building good policy.
And that's and that's where, just, to be clear, I mean, this is what I struggle with, right? And what I think listeners might be struggling with who are following your process, which is this is extremely insightful and I think useful, and yet we seem so far as a practical matter from being able to think in those terms. And so which is something that we'll have, I'm sure, more discussions about both on air and off air for that matter. But I want to push on this point about our lack of preparation for the technology, much less the thinking this way, by asking you to comment on a story that NBC reported a couple of days ago involving
By the way, before we jump into that, because I want to jump into it full force. There's three quick things, and we can take them later. There's three huge problems we have this second.
Go ahead.
Regarding what you're saying. One is incompetent legal AI. People just aren't doing it well. It's like getting an upgraded engine, but not upgrading your brakes or your gearing mechanisms, or like where you can go, your mapping. Like we're incompetent at using this. It's just a very, very powerful engine, and we don't know what to do with it yet. And I think hopefully the book helps, and the next book will help. Second, ethical AI. Ethical AI is amazing in practice. It'd be amazing to do, but I worry that it's really just a tool to keep lawyers out of the engineering room. And we have to be there at ground zero, at the beginning of the creation of these things. Otherwise, you're going to have massive, explosions and things and Napster-like events. Three, the AI companies are trying to prove their own fidelity. They're trying to prove, ours is the best and the most ethical and the most legal, and here it is. And you can't. You need outside audit or whatever it is. It's both a moral hazard and a mathematical impossibility for these companies to test themselves entirely. We just need checks and balances. That's all. Anyway, sorry to interrupt ABC.
So that third point is something I would like to take up with you on a future show, and it's work that I'm doing professionally in my day job as a law professor and someone that focuses on trade secrecy and AI, and something I'm going to actually take up on a different show on the Hearsay Culture Network called Secret.
Yes.
The second point, though, the ethics as a red herring point, is something I want to come back to because I do, unfortunately, it can very much be a diversionary tactic to avoid regulation. But before we go to that, and I appreciate those points, NBC News reported on January 22nd that a fake robocall using the apparent voice of Joe Biden was sent to New Hampshire Democrats, urging them to not vote in the New Hampshire primary, and apparently coming from a phone number that is in fact the phone number that would be identified with the Democratic Party. I want to play the clip that NBC News shared and then ask you a question about it. Here's the actual recording of the robocall.
A bunch of malarkey. You know the value of voting Democratic when our votes count. It's important that you save your vote for the November election. We'll need your help in electing Democrats up and down the ticket. Voting this Tuesday only enables the Republicans in their quest to elect Donald Trump again. Your vote makes a difference in November, not this Tuesday. If you would like to be removed from future calls, please press 2 now.
Now, apparently, the call also included a phone number, right? As I mentioned, and maybe a phone number that could have been called. Now, a disciplined ear hearing that, it sounds a little stilted, right? It also is weird that the president would be doing a call saying don't vote. All of that, though, falls under the heading of, I think, sophistication, media literacy, but at least NBC News reports that at least one person thought, it's weird that the president's calling me. This is where we are right now, right? We obviously have an election year coming up, which is going to be full, presumably, of this kind of behavior. How do we deal with this? I don't mean in the broadest sense in terms of regulation, right? But how do we deal with this, given that this is where we are right now, right? Where this technology exists, in isolation. If you took 5 seconds of that clip, I would have thought it might be Joe Biden speaking, right? But it's the context that makes it weird, not the sound, and of course the technology generated it.
So it's amazing. So I'm gonna quote Professor Swift, first name Taylor. It's one of my major IP references.
Yes.
In a bit. Last summer, but I'm going to tell you the same thing I told the SEC Enforcement Division. I think it was June or July last year. I'm not sure exactly. And the reason I quote Professor Swift is that she, for whatever reason, has made some brilliant business decisions as well as great artisan reasons, decisions throughout all this period, right? And so IP has very sophisticated IP philosophy and usage in some of what she's doing. And then critically, when there was a crypto blowout and every celebrity a couple of years ago, and every celebrity on earth, I'm not going to go into entities, but they were endorsing this new crypto exchange. She, like one of the few big celebrities, said, "Why is this not a security?" And so she was one of the only ones, unlike a lot of very, very famous athletes, that said no. So what I told the SEC enforcement, and this content is public, even though it was a private demo and set and workshop, is that now the crypto scammers are not going to need to hire Taylor Swift to get an endorsement. They're going to create fake Taylor Swifts and spike assets in right. Whatever exchanges they're in, and they're going to create fake Taylor Swifts. And
of course, by the time we figured out it was fake, it would be too late.
It's too late. So you need legal AI to help enforce it and police it. You need
ultimately prevent it.
And ultimately prevent it. So the causes of action exist within the FCC, the Federal Election Commission. And for listeners here, Dave Levine has one of the greatest sets of scholarship on trade secrets in voting machines and policies. So he's a big deal in election integrity and how that interacts with high tech. So you're going to have myriad Taylor Swifts promoting cryptocurrencies that are fake or non-existent, or promoting stock. And we have a huge problem as a country, because if you start censoring people, people are going to say, oh, you're only censoring the right or the left or the center or the north or the south. In this case, it's a little bit nice, because in terms of enforcement, because you can isolate it. It's not someone saying something controversial. It's clearly a fake presence. It's a fake person. It's clearly fraud. it's a malign influencer. And a lot of these influencers, they're foreign. So they're coming, a lot of cases, from outside. They create bots. They want to divide the country so that we're useless to stop them from whatever malign acts they're dealing elsewhere, invading Ukraine, whatever it is. So malign actors and things like this, I think it's actually easier to enforce from a legal perspective. And again, not going into what claims might be available criminally as well as in civil. But you got to be super, super fast. So we need these counterbalancing things to happen. They will interact with the private sector and private fora, and the private fora can't be arrogant about them. Again, they don't want to be in the business of selecting which speech is good and bad. It hurts their profit margins, and they get into trouble. You can't win most of these censorship debates. So I think we're going to see a massive amount of this, and we need legal AI to balance it and at least inform and identify really a malign activity, addressing it quickly. And we have to have legal AI to do that. That legal AI some of it's going to be private, some of it should be federal. The other thing I said to this institution, which these folks managed trillions of dollars of stuff. And that's probably an understatement, tens of trillions of dollars of stuff. They need to have their own AIs. They can't just rely on somebody else's AI. They need to have their own native systems that they can develop and manage themselves, because they can't trust anyone else. There's too much risk from doing it outside, even if they want to use contractors and things like that. So anyway, two things. It's horrific. We're going to see way more of it, and we need the technology to counteract and counterbalance it.
And of course, we're experiencing this real time, right, with living human beings and living democracies, and we have to see where it stands. We only have a couple minutes left, Jay, for obviously discussions that could take hours, and I certainly will have you back in the future. But I'm going to quote you again.
Thank you.
I'm going to quote you again because, again, 2019, folks, I don't want to go over the top here, but this book saw a lot of things that were coming perhaps faster than anyone imagined. We were talking about regulation, and you talked about the unbridled, is the word that you use, development of software, which is kind of the ultimate question we're asking here. You talked about the concern about, and I'm quoting you, the unbridled release, iterate, scale, implode, hate software development cycle that keeps engineering and legal constantly at odds, and therefore engineering and citizen users, and through them regulators, at odds. You said in 2019, that's an argument for another day and another text, and here we are. And here we so now here we are. So
yeah.
That day is now. In 2 to 3 minutes, Jay, right? Do you have thoughts for a prescription on how, given all of the moving parts, including the reticence of the private sector to be regulated, the use of ethics as kind of a sideshow to regulation, all of the issues which obviously predate AI involving lobbying and different interests at play, not to mention money, right? Do you have any suggestions for how all of these divergent groups, some of whom are diffuse, like users, can possibly work together to regulate or at least to harness and address some of these concerns in real time as we experience them?
I love that question, and we could spend 3 to 4 days addressing it. I'd love to know your feedback as well.
You have 2 minutes to answer the age-old question.
Historical and analog, and then I'm going to lead.
Yeah.
One of my best clients was the General Accountability Office. It works for Congress. It's not left. It's not right. It's just like, here's the deal with the F-35. Here's the cost. Here's how many ships we have and how many we need. Here is the cost of this regulation as near as we can figure out. And they're really hardcore. We had to fight to get that gig, but they used our data and they reported what happened. Not what people wanted, not what different factions wanted. We have to do that here. And it's very, very difficult because most people have religion about policy. They don't like one kind of policy. I don't care. What's going to help people the most at the most aggregate and harm the least rights, but maximize rights. instead of litigation, we need to be figuring out cutting deals. And my next AI book is on cutting deals. How do we do that at scale?
A minute.
And the negative example is Napster. Napster is an example of an amazing technology and amazing utility that broke up an old monopoly about how you used to buy albums, right? But they did it illegally, and so it completely exploded. The opposite example was really, iTunes, which was followed by YouTube's acquisition by Google. They just cut deals. They made something happen so that content creators could survive and thrive. And the blow up one is Napster all the way. And again, it's not. And those were important IP rights. You want to help creators, big and small, but you also want to give people utility and not hide the ball from people when something better is out there. With music, instead of destroying this industry, let's figure out how to do it. So I think we have to cut deals at great scale, and that's the next book.
And that's what we'll be talking about next time, hopefully, with Jay Walker of Systems Legal, author of the 2019 book on legal AI, extremely timely 4 years later, published by Full Court Press. Jay, thank you for joining me today on Hearsay Culture and the Hearsay Culture Network. I look forward to further discussions.
Likewise, it's been delightful. Thank you so much, sir.
The Hearsay Culture Network is in the process of our big launch with new shows that you can find out more by going to hearsayculture.com. For now, I'll simply thank you for listening to Hearsay Culture on KZSU-FM Stanford. Stay tuned for more diverse programming and have a great day.